All right, so today we are going to be looking at a case, Honig versus Doe. This was a case that was decided by the Supreme Court in 1988. And so let me hit present so you can see it. And the facts in this case are that John Doe, which obviously the names have been changed for confidentiality purposes, was a 17-year-old student who attended Louise Lombard School in San Francisco, California. He was a student with emotional disabilities relating to impulse control and anger issues. In 1980, Doe choked another child who was taunting him, and while he was being taken to the principal's office, he kicked out a window. Doe was suspended from school and recommended for expulsion. He remained out of school while the expulsion was being decided upon. Doe brought an action against school authorities under the Education of the Handicap Act. Then there was another student, Jack Smith, who was emotionally disturbed, who was repeatedly verbally hostile and aggressive with his classmates. He engaged in disruptive behavior and was eventually suspended indefinitely pending an expulsion hearing. Jack Smith brought an action in district court, essentially identical to the one that was brought by Doe. Once he learned of Doe's action, Smith joined Doe's suit as well. So the issue in this case is thinking about, can disabled students be excluded from classroom instruction during the pendency of proceedings to review decisions concerning their education? So can students remain out of school while they are waiting on an expulsion hearing? That is students that have disabilities. So in this case, the United States Supreme Court held that state or local authorities could not exclude disabled students from the classroom during the pendency of proceedings to review decisions concerning their education for behavior that grew out of the students' disabilities. And this case was mentioned in our book in Chapter 5, and I'm going to read you just a small part from that. And so it says that the fundamental issue confronting the High Court was whether the stay put provision of the Act prohibits states from removing children from school or for violent or disruptive conduct stemming from their disability. Justice William Brennan, writing for the majority, reasoned that under the Act, states may not remove students with disabilities from classrooms for violent or disruptive conduct that stems from their disability. The language in the IDEA clearly prohibits such action while any proceedings are pending. However, though once this case made it to the Supreme Court, the court concluded that the case was made for Doe because the fact that he was older than 21 at that time. So the reason behind this and the rationale is that under the Education of the Handicap Act, the school could not keep students out of school awaiting the results of their expulsion hearing. The court did declare that a suspension greater than 10 days constituted a change in placement. Under the stay put provision, children with disabilities must remain in their current educational placement during any review proceedings unless parents and educational officials agree otherwise. So some other opinions in this case were, the school really believed that the behavior of these students were a danger to other students that were within their placement, and that's what they argued in court. And thinking about what do we know as principals, what do we need to know as principals, this case really stood out to me a lot because I feel like this is an area that I definitely need to grow in. Being a general education teacher, although I have had students with different behavior needs and students that have IEPs, I'm not as familiar with the rules and with the guidelines and the laws that deal with students that have disabilities. So, looking at the chapter on individuals with disabilities and really looking at how you discipline students that have disabilities, there's a lot that's involved to it. And so, first and foremost, I think as a principal, the most important thing is that you know the rules, you know the laws, you know what their IEP says, you know what limits you have, you know how much they can be suspended, you know what behaviors they need to be suspended for. And when you're only dealing with 10 days of putting a student out of school, and you have a child that might have violent behavior, I think that it's so important to be proactive in that and make sure that you have a strong relationship with their parents, and that you're working as a team to try and give, students that have these disabilities what they need. And, but from the law side of it, as principals, it's so important that we know the rights of these students, what their rights are under their, IEP or under their BIP or, under the IDEA. But I also think that on a relationship side of that it's so important that I've just seen in my work as a classroom teacher, students that have struggles, that building those relationships with their parents, making sure that their parents know that you're on their side, you're on their team, you're there to fight for them, you're there to work with them, and whatever things that work for the parents at home, you're willing to try in your classroom, or, as long as it will work within the walls of your classroom. But yeah, this is Honig versus Doe, court case that was decided in favor of the students in 1988.